So good morning, everybody, and welcome to this morning's hearing of the Joint Standing Committee on Health and Human Services. We'll be hearing one bill today, and if things go as we hope, we'll quickly go to a work session following that and deal with that bill right away. And then we have language reviews of about 8 bills and a letter to go over that will be going out from the committee. So that's our agenda for the day. We will be taking testimony on LD 2027. Right now, we don't have a lot of people signed up to do that, but you're welcome to join us if you'd like. So let's begin with the introductions, and I saw Representative Zager there.
Thank you, Mr. Chair. Good morning, everyone. I'm Sam Zager. I am honored to represent District 41, which is part of Portland.
Good morning. Welcome, Representative Lemelin. Oops, not hearing you.
Can you hear me now?
That works better.
I'm Michael Lemlin. I represent House District 88, Chelsea, Jefferson, Whitefield, and half of Noblesboro.
Thank you. Representative Stover.
Good morning. My name is Holly Stover. I represent House District 89, including the towns of Boothbay, Boothbay Harbor, Southport, Edgecombe, Westport Island, and South Bristol.
And let's see here. I can look around for everybody else. Representative Griffin.
Good morning, everyone. My name is Abigail Griffin. I represent House District 102, which is Glenburn, Livia, and Kudeske.
Representative Connor.
Thank you, Mr. Chair. Good morning, everyone. My name is John Connor, and I represent part of Lewiston.
Representative Craven.
Thank you, Mr. Chair. Good morning. I'm Margaret Craven, and I represent House District 59, which is part of Lewiston.
Representative Perry.
Good morning. I'm Representative Ann Perry. I represent House District 140, which includes the communities of Indian Township, Baileyville, Barron, Calais, Charlotte, Robinson, Perry, Pembroke, and Pleasant Point.
Welcome. Representative Javner. Good morning.
Good morning. My name is Kathy Javner, and I represent House District 141, which is located in Penobscot and Washington counties.
Senator Moore.
Good morning. I'm Mary Ann Moore, and I represent Senate District 6, which is all of Washington County, as well as Goldsboro, Winter Harbor, and Sullivan in Hancock County as well.
Representative Meyer.
Thank you, Mr. Chair. I'm Representative Michelle Meyer, serving Southern Maine's District 2, which is all of Elliott, where I live, and parts of Kittery and South Berwick.
And I'm Ned Claxton, honored to represent Senate District 20, which includes the folks who live in Auburn, Minot, Mechanic Falls, Poland, and New Gloucester. And we're joined by a couple of our staff members today. Sam, want to introduce yourself?
Sam Seneff with the Nonpartisan Office of Policy and Legal Analysis.
And Anna, if you're ready.
Hi, I'm Anna Broom. I'm the other legislative analyst for this committee, and I also work in OPLA.
And Karen.
And I'm Karen Thomas, happy to be the clerk for the Health and Human Services Committee. My email address is hhs@legislature.maine.gov should you need any assistance.
And the last 3 people to introduce themselves all have helped the committee get to where we are right now, and can't be grateful enough for that effort and support. So I think we'll start first with a public hearing on LD 2027. And I'm going to see if Mr. Bugai, there he is the one to present this. So I'll bring him in. Welcome. Good morning.
Good morning.
So are you here to introduce LD 2027?
I am. So thank you. Good morning, everyone. And good morning to Senator Claxton, Representative Meyer, and the members of the Joint Standing Committee on Health and Human Services. My name is Dean Bugai. I'm the Children's and Behavioral Health Manager with the Office of Care Services, and I'm here today to introduce and speak in support of LD 2027, which is the resolve regarding the legislative review of portions of Chapter 101, Medicare Benefits Manual, Chapter 3, Section 97, Private Non-Medical Institutions, which is a late filed major substantive rule of the Department of Health and Human Services. This bill represents legislative approval of a provisionally adopted major substantive rule. I also just wanted to note and offer my appreciation to the committee chairs, legislative council, and OPLA for their assistance in getting this major substantive rule to you prior to the end of the session. Greatly appreciate it. The changes in this rule were originally implemented in Chapter 3 through emergency major substantive rules effective November 1st of 2021, which implemented the reimbursement increases in Chapter 3 to support final adopted routine technical changes in Chapter 2 of our Section 97, which was also effective November 1st of 2021. The Chapter 2 changes implemented various new requirements for our Appendix D providers, which are child service providers, per the Federal Family First Prevention Services Act, also known as FFPSA. And it added new covered main care services. Chapter 2 also stated new requirements on our Appendix B providers, which are our substance use facilities, and broadened those covered services as well. As you know, emergency major substantive rules are effective up to 1 year or until the committee's review. And so to make these reimbursement rate increases and other changes permanent, shortly after the issuance of the emergency rule, the department initiated a proposed major substantive rule for the Chapter 3. The new reimbursement rates were authorized by the legislature pursuant to Public Law 2021, both Chapters 29 and 398, which was the budget and supplemental budget. The rates are consistent with the independent rate studies completed for our Appendix B and D services. And the department is seeking approval from the Centers of Medicare and Medicaid Services for the increased Appendix B and Appendix D rates. Just to highlight a few of the changes for the committee. In addition to the above rules, we updated names of certain services to gain consistency with changes adopted in Chapter 2 of this section. To get into a few specifics of the rates themselves, we created 2 tiers of reimbursement for medically supervised withdrawal services, one as a standard rate and one as an exception rate for low nursing staff in case of substantial workforce challenges. We also consolidated reimbursement into a single level of care for certain children's residential care facilities, including our mental health facilities and intellectual and developmental disabilities. Additionally, we have added reimbursement for a new service called aftercare services to comport with the FFPSA requirements. And while we originally adopted in November an hourly rate of reimbursement, pursuant to public comment on our rulemaking, we have amended that rate to a quarter hour of reimbursement to add flexibility, allowing providers to be reimbursed more consistently for their activities. Please note that the emergency major substantive rule reimburses, as I said, based on the hourly rate for aftercare, and that shall continue to be effective until the time at which the legislature authorizes and department finally adopts these major substantive rules per 5 MRS 8072. The department plans to retain the hourly reimbursement in the future final adopted rule, so providers may know how to seek reimbursement for aftercare from November 1st of 2021 to the effective date of the final adopted rule. We also established, we also established a rate for providers to be reimbursed for mileage associated with aftercare services to cover their time for face-to-face visits with members and their families. So pursuant to 5 MRS 8072, the department submitted this provisionally adopted rule to the Maine legislature for its review and action. And this bill will not have any fiscal impact as the changes in the rates have already been appropriated, as previously noted from the budget and supplemental. And I'll be happy to answer any questions, and we'll plan to attend the work session. So thank you.
Thank you very much. Are there any questions about LD 2027 for Mr. Bugai? Yes, Representative Perry.
Yes, I guess the question I have is, you were talking about, and I'm really trying to understand this, changing from hourly reimbursement to 15-minute reimbursement in some areas. What is the advantage of that?
The advantage of it is that there's a number of coordination activities that providers would do that don't take up to an hour. And so the way our rules currently would look is that they potentially would not be able to be reimbursed if they were less than 1 hour. And so by shifting to a 15-minute, it allows the providers to be able to be reimbursed for those activities. So that was a very good comment that we received, and we're happy to make that change.
Representative Craven.
Thank you, Mr. Chair. I have a question, but I thought I understood that, for example, services for people with ID and already were reimbursed in 15-minute increments. Is that right? Or
these are for our residential care facilities. So these are predominantly for, well, so our residential care facilities get a daily reimbursement. The aftercare services that we are just discussing, which was hourly, that is a service that would be for any youth, whether it's ID or mental health, that's in a residential facility. It's basically like a follow-up and support service that the residential providers provide to the members after they transition to their, from the facility to their home. And so it's not specific to diagnosis, but you are correct that many of our community-based services are reimbursed at a 15-minute currently.
so could you define aftercare? Is that when somebody is like dismissed from the hospital or something like that, or?
Yeah, so when they're in our in the residential care facility and are ready to be discharged to their home, the aftercare is that the facility will follow up with the parents and the youth in their home after discharge to see if there's any support that they need, whether it's getting linked up to new resources, checking in to make sure things are going well. It's a way for the facility and the clinical team to follow up to assure a more successful transition.
Thank you.
You're welcome.
And that work is done by people that the individual would already be familiar with because they're from the res care home?
Correct.
Okay. And so the goal is to help them stabilize at home and stay there as opposed to having to come back into a stabilization setting.
Absolutely.
Okay. Any other questions? So as I read through the comments, it looked like you got a couple of public comments and incorporated changes from both of them as making this a more robust proposal.
Correct.
And those changes have already been in place because this was initiated by executive order, right?
Well, the change for the 15-minute is not already in place. That is, dependent upon the committee and that process.
Okay. And do we need to put an emergency preamble on this?
I believe there is one on the bill, but yes, I think an emergency preamble would be great.
Okay, so Sam's nodding his head and said, I'm late to the party, that there already is one. So, okay, great. All right. Any other questions? Very good. Thank you for being here. Mr. Bugai, don't go anywhere because that'll conclude the public hearing portion of this consideration of LD 2027. I'm going to turn it over to Sam. So are there some questions there? Senator Moore.
No, I was just going to make the motion that we go into work session on LD 2027.
Thank you. Is there a second for that?
Second.
Thank you, Representative Zager. So we are now, all those in favor of going into a work session, please show of hands. Very good. It's unanimous, those present. So we are now in a work session on LD 2027, and we happen to have an analysis of it ready to go. Thank you, Sam.
I'm going to go ahead and share my screen. The last times I get to do that this spring.
Let's hope.
For my bill analysis, basically I bulleted out what the rulemaking does. I think Mr. Bugai already covered this in more detail than I have here, so I probably don't need to read through it again, if that's okay with folks. Happy to answer any questions about any of those services with Mr. Bugai. I added some links here to the main care benefits manual, relevant sections. There's not a preliminary fiscal, but I think Mr. Bugai did mention that the funds for these changes have already been appropriated. And yeah, that's about it. I don't have any drafting concerns with the rule, and I have no other policy concerns with the rule.
Very good, thank you. Any questions related to that analysis? And as always, thank you for those links. I'm always learning something with having those so readily available. Any comments? Yes, Representative Meyer.
Thank you, Mr. Chair. I would move LD 2027 ought to pass.
Second.
Moved and seconded by Representative Meyer and Representative Craven. Thank you. Is there any
We need
discussion,
to do
conversation?
that as amended.
Well, I was going to ask next about that. We don't have a fiscal note, so that doesn't count. And then does this yet? But does this count? Did we change the language at all when it went to the department, Sam? Were there any revisions made to the regional bill?
There's no revisions to it. Well, actually, I would do it as amended just in case there's a fiscal.
Okay.
And then with the committee's permission, if I don't need to, I can switch it back to an, if I have that permission ahead of time, maybe we'll do it as amended, but if we don't need it, we'll.
Okay, Mr. Chair, in light of that, I would amend my motion to LD 2027 ought to pass as amended.
Thank
Agreed.
you. And seconded. Thank you. Any further discussion? So let's do this with a roll call and ask Karen to collect the votes on the ought to pass as amended motion on LD 2027.
Thank you, Senator. Representative Zager.
Yes.
Representative Zager. Yes. Representative Lemlin.
Yes.
Representative Lemlin. Yes. Representative Stover.
Yes.
Representative Stover. Yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry. Yes. Representative Madigan. Representative Madigan is absent. Representative Craven.
Yes.
Representative Craven. Yes. Representative Connor.
Yes.
Representative Connor. Yes. Representative Griffin.
Yes.
Representative Griffin. Yes. Representative Javner.
Yes.
Representative Javner. Yes. Senator Moore.
Yes.
Senator Moore. Yes. Representative Meyer.
Yes.
Representative Meyer. Yes. Senator Claxton.
Yes.
Senator Claxton. Yes.
So that's unanimous of those present. And thank you for being here, Mr. Bugai.
Thank you very much. I really appreciate your time and attention to this matter.
This has been a significant priority for us this session, and we're glad to see some additional progress being made. So that's great.
Absolutely.
All right. Any other things to do before we get to language review? And who wants to go first, Sam or Anna?
So I think 1824 is advertised for a work session at 10:30. So we could run through a couple fiscal notes beforehand.
Okay.
If that works.
If you would, and one or the other of you start with the notes we
Sure.
got.
I'll go ahead. Share my screen here. All right. So I have a fiscal note here for 1915. This is an act to improve intensive behavioral health and public safety case management services. So As expected, there is a fiscal to this bill. General fund, $338,170, and other special revenue, $147,156. As you recall, this includes the $5 an hour stipend, as well as an additional $1 for folks with master's degrees for intensive case managers. So I think the committee was probably expecting a fiscal on this, and indeed there is one. So any questions about that?
Representative Meyer?
Thank you, Mr. Chair. Sam, how many individuals was the fiscal note calculated to impact?
Let's see. I don't have that. I can look back. While Anna's doing her things, I can look back and check. I know that we had asked for that information, and I had it, I think, as part of the questions for the work session, so I can just check that. Well,
Sure.
If you do
Thank
the
you.
math of $5 a wage hour and assume 40 hours, then that's I'm 2,000 hours a year. That gets you to 10,000. So there's probably 30 something folks.
That sounds actually very accurate based on my memory of the number of physicians. That's some good on the fly math, Senator. All right. So the next one I've got is 1994. So this one is exactly as expected, because if you'll recall, for the Progressive Treatment Program Fund, the bill itself had appropriated $160,000. So this is what we anticipated the fiscal would look like.
Very good.
And I also have, looks like we have 7 minutes, so I'll pull this up. So this is an act to create the ALS incidence registry. So the language in here, if you'll recall, the committee had asked that I add some language that allows for MOUs with any national registries with appropriate protections in place for confidentiality. So I did come up with some language and ran it by the department to make sure that it worked with their internal confidentiality policies, and they ran it by folks in their administration to be sure that it was in line with their policies around data confidentiality and bidirectional MOUs. So this is the language that they had agreed worked for them, and I agree that it meets the expectations of the committee as you expressed in the work session. So
Thank you. Are we going to need to go to judiciary to request a freedom from FOA?
So I don't think so, because this is already, because it's health data, it's already falls under current protections. I will double check that with my colleague in judiciary, but I don't think so.
Good.
All right. And I have the letter as well, but I didn't know if that might need a bit more time than we want to take right now.
Well, we might as well, we're here this morning.
Okay.
We're gonna get through all of these.
Okay. So this is the racial impact statement report. This, as you'll recall, the committee had discussed the process by which the committee received racial impact statements for these 3 bills. And what I did was go through and answer specifically the questions that had been posed in that January 5th letter to the committee from the council. And the feedback, as you'll recall, I think that probably the biggest point the committee wanted to make was the timing of the racial impact statements, and how they came a little too late in the process to be as helpful as they may have been, because the committee got them after public hearings. And in some cases, it was well after the public hearings because they were actually last session. So the bills that you had before you as amended were quite different than as they started. So by the time you had them, they were kind of moot. So I did try to express that concern with the timing. as well as the fact that some of the information contained in the racial impact statements was not specific enough or kind of drilled down enough to be as helpful as it may have been to the committee. So while things like national level data can be kind of helpful on a broad level with policy discussions, when you're looking at specific legislation, more state level data would be helpful. So I did try to express those opinions to the committee, and I'm happy for any feedback or changes the committee would like to make, and otherwise we'll get this sent out.
Did everybody have a chance to review that or a chance to ask any questions about it? Do you know, Sam, whether Ledge Council is expecting us to present this at a meeting or not?
No, it's
Okay.
it's just a report back.
I don't think I could add anything to what's here, so thank you for that.
And I
Okay.
got through everything that I had to get through, and we're just about at 10:30.
Well, we don't exactly need a break yet. Anna, do you want to start? Do you want to do a couple of your language things? I can't hear you yet, Anna.
Sorry. Okay, I'm not going to start there. I'm going to start. Are you looking at 1825?
Yes.
Okay, so this is a bill you've actually seen already. This is the majority report. Since we were, if we hadn't been meeting, I would have just sent this by email, but since it was a divided report, it seemed worth using the time that we have. So you've already seen this language. This is the language that limits the hours and driving of child protective caseworkers. And I just wanted to show you, and you've already seen the language, although it is below. I just wanted to show you that it was a no fiscal impact fiscal note. So this is the language right here, where you added in this language of the caseworker supervisor and the commissioner or designee directing a caseworker to exceed the maximum number of hours. And this was determined in department policy, which is what you all decided at the last work session for that. So that's that one. And then 1773, this is Margaret Craven's amendment related to the global settings rule. You've already seen the language, although I can certainly bring it up if you need it. And this just basically says that the bill prohibits the department from enforcing the rule that had been adopted until January. There's a federal requirement that the department must be in compliance with the rule by March 17th, 2023, and delaying the enforcement of the department's rule could impact its ability. That's because Luke is not in the revisor's office. There's a typo there. Ability to show compliance. If the department is not in compliance by this date, federal funds of around 100 million annually would be at risk. So he can't show a cost because there's no actual cost. There's just a risk. So that's the fiscal note for Representative Craven's amendment. And I can't see her while my screen is while I'm sharing my screen, but I'm sure she'll say something if there's an issue there. And I do just want to mention that Representative Craven wasn't at the work session, the amendment review where we reviewed that her amendment, but I got the okay from her afterwards. So LD 1877. So this one is more of an issue. This is the majority report. You've already seen the language, but I want to go back to the language before I go to the fiscal note because I did not initially write this particular amendment. So when when the majority switched to this amendment, I wasn't really particularly prepared for it. So I've done a fair amount of work since then about this language here, about the implementation of this section being pursuant to being consistent with the requirements of the federal Medicaid drug rebate program. So this language doesn't really do anything to fix the issue that you have around this bill. As you heard at the public hearing in the work session, the problem with this particular policy is that it impacts the drug rebate agreements that the state has with with drug companies, and some of those agreements are also multi-state. So this language, and one of the things that I wasn't really sure about is whether this language would have an impact on people on the ground. In other words, would this have any kind of limitation on a person who was being prescribed one of these medications? The answer to that question is no. So it's all about, there's two sides to this, right? There's the side of the cost of the impact of the rebates, and what is the impact on the folks who are being prescribed. And I wasn't really honestly sure, and I told you that when you revoted this at language review, that I didn't really know what impact it would have. So this language doesn't actually do anything, because this is about the federal law. So of course we're complying with the federal law. So that in a way doesn't actually do anything at all. It wouldn't matter if it was there or it wasn't there. I just want to remind you that we do have this language here of the state plan amendment, that it only goes forward if the state plan amendment is approved, and that doesn't change, and that's language that you would want to have. So now I'm going to go to the fiscal note, which is really kind of the point here. If I could get my things out of the way, I could show it to you. Okay, so this is the fiscal note. So you can see here that there's a general fund cost of $737,470 in fiscal year 23. That is based on an estimate that OFPR and the department have to do in terms of when it would go into effect. And because it requires a state plan amendment, this is based on going into effect in April of 2023. So this is a 3-month amount. And then you can see the full estimate of 2.9, this is just general fund, 2.9, almost 5 million, and 2.95 million in when you have a full fiscal year, and that obviously does draw down federal match. So I'm gonna stop sharing if that's okay, so I can sort of see you all, but you do have this in your inbox. So the costs in that fiscal note are a combination of two things. One is increased drug costs, and the other is the loss of rebates. So, and that's because the preferred drug lists for these conditions would go away with this bill, if this bill is enacted. And so this affects the rebates with manufacturers and the multi-state ones. We can't require drug companies to give us rebates. So that's why that happens. And the last thing I want to mention that's not in the fiscal note that I might not have thought of, but was pointed out to me, this is an estimate, obviously, because this is based on rebates and costs and things that we can't, you know how fiscal notes work. There are some things that are easier to count than others. It's easier to count how much it's going to cost to add a supplement to a person who's working at Riverview, because how, it's more of a known world than it is with this. But the one other uncertainty that this fiscal note can't include, that I just want to make you aware of, just so that you do know that it's possible, is there are new drugs being approved all the time. And if there were a new drug that was expensive that could be used to treat one of these conditions, that's not included in the fiscal note, because we can't know that. So I just wanted to clarify, because I'm sorry I didn't do a particularly good job at the amendment review about what that language does that was being added, and it doesn't actually do anything. The other language does. The unallocated language is important about the state plan amendment and so on. But that particular language doesn't fix the problem that you're trying to fix, because it's not fixable. There will be a cost to doing this, and that's what you have to understand. So I don't mean to get on a soapbox here or suggest to you that there was any kind of issue with what you did. It's you're the legislature, you can choose what you want to do, but I did think that you needed an explanation of the fiscal note, and I needed to figure out how the fiscal note worked as well. So that is the impact of that one. So that is that one's getting ready. That one is ready to go out the door.
So that fiscal note really is an estimation if nothing else changes in the future.
That's correct. And if something changes in the future, it would be more expensive. Like that's a definite.
Unless a drug comes to the end of its 7 years protection for patent, and there's now a generic, which
Yes,
is
that's
it could drop.
well, yes, except that the point of this is that a person would get the prescription that,
Right.
yeah.
So
But yes, you're right.
Perry.
Yeah, I understand what the cost is initially, but I think one of the reasons we're asking for the study is to show.
What a study.
Oh, and we can't hear you.
Sorry, I'm using my hands to demonstrate what I'm saying, so I'm not holding down the space bar. So I'll keep my hands in one spot, and then in that section, there is something that says they're going to follow the data in terms of what's happening with that. And the purpose of that is really, and I think that we will see that there will be a decrease in hospitalizations and emergency trips if we're able to treat them appropriately and accurately to begin with. And that's why that's coming forward. So whether the fiscal note will stay or get bigger or not, we really don't know that unless that data is collected.
Any comments? Thank you for that.
So I have one more fiscal note, or you can do the work session. It's up to you, Senator.
Why don't we go to the last fiscal note?
Okay. So it's not a fiscal note, actually. I said that, didn't I? Yeah, I said that, didn't I? But I didn't mean that.
I was listening to you.
Yeah, I know. I'm sorry. I'm wrong. I'll take that. Okay, this is the minority report. I sent this out last night. I know it's good with Representative Zager, or at least I think it is, but I don't. There are obviously four folks on this particular report. So I have marked up the original bill was the easiest way to do this, to show you what it would look like. So what I was told at the, or asked to do at the last amendment review on this bill was to turn this into a main care eligibility for all, rather than a program that was intended to be the equivalent of kind of a single payer program. And that was because the amendment that originally I was asked to draft was to allow folks who are content with their insurance program to keep that. That could only be done temporarily, because the intention of this original bill as it was drafted was to move to a main care for all program. And so the only way that I could do that after the work session was to do that as part of the sort of temporary plan. Representative Sylvester had sort of said it would take several years for the phases to follow through. So in the meantime, that could happen, but there was some unhappiness with that particular outcome. So I was asked to draft the sort of main care eligibility for all, which means anybody who wants main care could sign up for it. I kept the phases in the absence of any different direction. So the first part really doesn't change much, except for the title and using the main care member language that we currently use, because it no longer applies to all residents of the state. And then all of that just changed. The years were just going to change anyway, because this is a bill from last year. But I kept the phases because I wasn't told to do something different. So this would allow folks, depending on their federal poverty level or on their income, to sign up for main care if they chose, on a sort of phased in basis. And then the eligibility, the task force just changes the name. It doesn't change much else with them, except for, once again, the dates. And this language gets struck out because this is moving over the credits you get on the exchange into the program, and that's not a thing anymore. I'm hoping you won't. I'm hoping that you won't ask me to draft what if people are currently on the exchange and moving into main care. I suppose that could be something that you might want to do. So if you do want that, I guess I can tweak that a little bit so that it doesn't require it, but allows credits to follow them over. I didn't think about that until I was looking at that right this minute. And then this was a correction that we talked about already about consultants, And then I included the consultant language at the bottom because it didn't make sense to me to actually move it into the allocated language since it's a one-time thing. And so I just need to know if the 4 folks who are on that minority report want that particular amendment, or there is some differences between the minority report that I do not know.
Thank you for that, Anna. That was a fair amount of work. Representative Zager?
Thank you, Mr. Chair. I thank Anna so much for that extra work. I know it's a very busy time. I'm comfortable with the language as presented.
And I am too. And I actually like the way that read.
So I know, I guess the other 2 folks that are on that report are not here right now. So I will, if this email is, this language is in their email from yesterday. So if one of those 2 folks contacts me and says they're not happy with it, then I will do something about that. Otherwise, I will not be touching it.
Thank you for that work.
Okay. So yeah, I'm gonna let Representative Stover do whatever she needs to do, and you'll just let me know if you need me, Representative.
Thank you, Anna. Let me just, I have to just go bring the document up.
So now we're officially in a work session on LD 1824. Was that tabled? So I need a motion to take it off the table before we begin.
So moved.
Second.
Thank you, and seconded, Representative Zager and Representative Meyer. All those in favor of taking LD 1824 off the table for our discussion in a work session, please indicate. That's a unanimous of those present.
Thank you. So LD 1824, as we discussed during the hearing, was a provision to provide indigent legal services to families under Child Protective Services during that initial assessment phase, recognizing, 1, we do not have a public defender system in the state. 2, people who are have open protective cases oftentimes cannot provide an attorney for themselves, a civil attorney for themselves to represent their interests and themselves during those proceedings. 3, that Child Protective Services involvement in your family can be a particularly traumatic time, and both for the parent or parents and the child, and that it is a limited period amount of time that this initial assessment phase comes and goes, and it results in either moving forward with a protective order to remove the children from the home, or a series of other things that can happen, including kinship or out of home placement, or it gets closed after the initial assessment. But what doesn't happen oftentimes in these cases is any representation for those families. The Child Welfare Advisory report, MCWAP report, had described the need to have to have legal representation for families during the assessment phase as one of their recommendations. It has come up before. There's been discussion as we look at this larger systemic issue around child welfare. This is one thing that I think we could do. However, bringing it forward, it seemed quickly. It was at the very end of our work. It was a lot to digest for us. It had a fiscal note of $1.5 million, which again was a large fiscal note. And that shouldn't really distract us from the fact that this might be the best thing, one of the best things we could do. So I'm proposing that we pull that back and that we look at a study group that could work between now and the beginning of the 131st, and that we have the opportunity to determine what a pilot project could look like to provide legal representation to families in child protective cases, and that commission that legislative group would be comprised of, you have the document in front of you, but I'll just quickly go through it. 2 members of the Senate appointed by the President of the Senate, 3 members of the House of Representatives appointed by the Speaker, that there be 3 members, 1 a parent attorney who's a member of the state bar, 2 a member of the Child Welfare Advisory Panel. Remember, I mentioned that this came directly from their work and their report, and someone representing that panel, a member of the Maine Commission on Indigent Legal Services. We've had representation at the committee from them before, and they do an array of indigent legal services across the state. As far as taking the sort of like not biting out of the apple, it was a bite out of the elephant. Assuming this so quickly or consuming this so quickly, I think this would allow them the ability to work with this committee to determine whether or not they are the best home for a project like that. And then the other 3 members could be a statewide organization representing domestic violence. I had said during the hearing, and I just want to remind us, oftentimes the non-offending parent has someone at their door from Child Protective Services saying, you, non-offending parent, are failing to protect this child from the elements of violence that are occurring in your home. And that can be from that parent being the victim directly or indirectly, the child witnessing that violence, which is a really as traumatizing for a child. Oftentimes, if you don't have representation as a victim of domestic violence, you can lose your children or have your children placed in out-of-home placement for failure to protect. And if we were to look at having domestic violence as a representative on this work group, I think we could address some of those issues more adequately. Another organization representing civil legal assistance. We can't name agencies by name. For the greatest example is Pine Tree Legal. And then someone representing behavioral health and substance use disorder. We know that we have a significant number of parents who end up involved in child welfare because of significant substance abuse issues in their homes and or mental health issues for the parents or the children. Someone from the commissioner's office or the commissioner's designee, and someone from the AG's office representing the interests of child welfare. So the purpose of this work group, if the committee agrees, would be to take the next 7 months, I guess it would be 7 months, and to do a thorough analysis of what exists in other states, what are best practice models, what are best funding models. There's at least one state I know of, and I think there's actually more than one state that's using some of the 4E federal funds to fund these programs in other states. So before we jump to that place of looking at the general fund as a possible funding strategy for civil legal services to represent parents in child protective cases, should be exploring all funding streams and what are the best answers to that for our state. So it's really moving the bill to establish a pilot, to establish a commission who can develop a pilot program. We'd have the time, the luxury of time to do the research, to vet this through a committee, to have public representation, public comment, and come back with a report no later than November 2nd, 2022. And hopefully in the 131st, we would be able to move forward on a proposed pilot project for child welfare. And that's what I have to propose to you today.
Well, are there any questions about what's been offered so far? Yes, Representative Javner.
Thank you very much, Senator Claxton. I guess I really don't have questions. Thank you, Holly, very much, Representative Stover, for your work on this. I have some few concerns, however, and that this is very serious. This is, a priority for all of us on this committee. It has been, protecting our children, and this could be a very important piece. We've added a lot to the child welfare already. I feel there's so much on their plates right now, and this timeline is just very short. And I just don't know if this commission is going to really be able to bring together the information that we have in such a short timeline. The other issue that I have is that, the report, actually, it says it comes back to the Committee of Judiciary. And so I don't know exactly what the trigger would be then for us to be able to receive that information about what is going to be happening for a pilot program that will therefore, in my opinion, correct me if I'm wrong, would actually be under the purview of the Judiciary Committee at that point. So I guess I do have one question. Would that pilot program then therefore be under the Judiciary? But those are my concerns. And with that, just know that I won't be voting for it. I do appreciate all the work that's been done. I just really feel there's a lot of pieces that are already been put in place. And I don't think the timeline is right for right now for this.
Thank you, Representative Javner. Anna, are we required to have the report back to the Judiciary, or could it come back to the Health and Human Services Committee?
You could have it go to both if you like. It probably should go to Judiciary only because Indigent Legal Services is under them and the judicial stuff goes to them, but you can absolutely include it to come back to both. And I do just want to make sure that, I know you know Representative Stover, but just to make sure that everybody knows that if you move forward with this, it goes to the study table, because the study table determines which legislative studies get off the study table. They usually fund things for 4 meetings. That's the norm, not necessarily the rule, but it is the norm. But I just wanted to let you know that that because the fiscal note's likely to come, after you finish meeting, but I can tell you what it's going to look like, and it's going to look like this is the amount of money that's on the study table, and it will cost this amount of money if it gets funded. But yes, if you would like to insert both committees in, Representative Stover, you can do that. Just give me a shout.
Representative Javner, would that address the concern around the committee assignment?
It would address that concern, Representative Stover. To be honest, I do think it should be in the Judiciary Committee. I think that is something that they have the knowledge for and understand the process of that, and what that would really look like. I think it should be in the Judiciary Committee. If we can get the report back, if this study continues to move forward and the commission is formed, I think, then we should receive that report, and that's fine for that piece. But again, I still just am, and this does just bring up another concern as well, as we talk about it and have the conversation that, I think this piece should be looked at very closely in the Judiciary Committee, for them to be able to have their input on what happens with that piece. Thank you.
Thank you. And I think, by forming a commission and being able to study this over the summer, what it may be ready for in the 131st is either a different bill with the information. So at least we have, it feels like we took the report recommendation, and I know MCWEP has done a tremendous amount of work on this, so I don't want to diminish that, but they've done a tremendous amount of back work on this. It brings that all together with new information plus additional research of other states, and allows us to look at what it could look like in Maine. And again, I think it's really important to look at what are the other funding streams that potentially exist out there that we may already have that we don't tap, instead of looking at the use of state general fund. I think it's easy to look at state general fund for things like this, but we know other states are doing this in a way, much larger states are doing this in a way that they're able to fund it through the use of other funds they have that exist that aren't tapped at this time. And I'm hoping that we can come back with a more creative strategy around funding a project like this as well.
Would you consider it a friendly amendment, Representative Stover, to add GOC, or would you bring it there without that?
We certainly can offer that to the GOC. That would be a friendly amendment.
That's probably the better way to do it.
But we can add, remember, the Health and Human Services Committee is the committee of jurisdiction. So when we return and we give this to Judiciary, I would think that we would also want to give it to the Health and Human Services Committee. We can add the GOC in addition to that, and it may be structurally, it may tie to some of the interest and goal areas that we see in the report that's being released on Friday. But I think I would also ask that we amend the Health and Human Services Committee with the Judiciary to receive this report, if that makes sense to you, Mr. Chair.
Anna, you're looking quizzical. Can we add?
Well, the awkward thing is that it isn't clear what the GOC's authority is in terms of reporting out bills. And studies allow committees to report out bills, and you can report out bills and Judiciary can report out bills. but GOC tends to use its members to put in bills that way rather than having, and they may have authority, but I've never seen it. So, you know, that's not a clear sort of settled question. So that's why I'm looking quizzical.
So what's the best way to get the information to them, given their significant interest in child welfare?
Well, I mean, I think as Representative Stover mentioned that, you know, you have legislators in who will be on GOC. It'll be a new GOC, but there's usually somebody from HHS, or, you know, you can just, you know, we're quite good at forwarding things to wherever they need to go, and it can obviously be forwarded.
That's good enough for me. So that would be, we would add HHS as the amendment to judiciary.
Yes.
Okay. All right. Any other questions, concerns? Not seeing any. That being the yes, Representative Javner.
Thank you, Senator Claxton. I apologize. Just real briefly, there isn't any possibility of moving the deadline out for the study, is there? It says, you know, November 2nd,
yes,
2022.
Okay, so the question is that there are sort of a couple of things at play here. The first is that we drafted this as, when I say we, on Representative Stover's instructions, we drafted this as much as possible to conform to the joint rules. The part that doesn't conform, because frankly we ignore it all the time, is that the joint rule requires a majority of legislators. I'm yet to start the study that has a majority of legislators, so it's a common one that is ignored. But November the 2nd is a standard date. It comes in. You know, it's related to the election. It comes into this legislature. However, if you think back to Representative Zaga's study, is a 2-year study, and so that comes in an entire year later. That's unusual to have a 2-year study, but that's why November the 2nd was picked. So you can pick a different date. It means that it's another thing that doesn't conform to the joint rule. It just means that the Legislative Council, which is the study table, can choose to amend it. So what I'm saying is, if you want to pick December 30th, I can put that in there. You just always have to know that anything that doesn't conform, which includes not having a majority of legislators, for example, so the membership, they can choose to change that date. So it's your call. If you want to change it to a later date in the year, you can. If you want it to be the following year, that's a different kind of problem, you know, starting with the fact that you have, you know, you'd appoint legislators this year,
right,
and then maybe some of those legislators are not there next year, and you've got to put in that mechanism to change it, but that's your call.
Any further thoughts about that, Representative Javner?
Yeah, to be honest, I don't prefer to actually move the date out. I think that, you know, this really is very important, and I think that if we can just start it again, you know, next session, and with those that survive November, if I can put it that way, and really take a deep dive, look at it. It's that important to me. I just really think that's the important piece. You know, our kids are that important, and I just don't want to rush it. I don't, you know, 4 meetings, it just doesn't seem enough. And I'm not ready to say that, yeah, I want to push it out. I don't want it to be that, to be set aside. And to be honest, I don't know how many studies are actually on the study table. I don't want this to get lost in the mix of what is already on there and what's not. And I don't want to rush it. It's that important to me. And I think that's where I'm at.
Okay, a couple of clarifying questions for me. Have you been on a study group or been involved with a study group to this point during your service?
No, I have not.
I just want to comment that the one I've been on, I was amazed at how quickly we were able to rally some people who knew what they were talking about and make some progress. I just offer that for what it's worth.
No, and that is very helpful. It's an extremely valid point. You're correct. I don't have that experience of working on the study group. So,
okay.
Yeah.
And the other thing that happened is we've also extended study groups at the request of the group. And so that could be, you know, we did a bunch of work in the first 4 visits, and we have another 4 to go. And so can we extend it? That happened in state and local. It carried over into January this year. It was due in December last year. So that's another possibility.
And if I could just comment, Representative Griffin and I served on the Long-Term Care Commission, and that was a behemoth amount of work. And I credit the talent of the staff that were assigned, who really did a tremendous amount of work in a short amount of time and finished a darn good report that we still are implementing. But it was a great report, and we did pull it through somehow. But I credit the staff.
Thank you. Representative Perry?
Oh, well, I was actually just going to add something. The PTP group that you and I were on extended its meeting so we could come back with a report and recommendations. So not everything gets done in 4 meetings. Some can, but we have the opportunity to extend that. And even if it isn't completely done, we can begin to look at what needs to change structurally and move on with more in-depth work. I hate not to start it. And I guess that's the piece I'm looking at, is that if we wait until next session, then we've got another year, 2 year, almost 2 years before anything gets really done and looked at. I really would like to see it starting to be looked at. Let's see what they come back with. We're going to probably find things we're not aware of, which is good to come back with so we can look at it more. And that's really why I think this is important.
Thank you. Representative Meyer?
Thank you, Mr. Chair. I would agree with Representative Perry as well. I have been on legislative committee. The level of expertise brought by each member is impressive. And as this committee has worked to begin to address and reimagine some aspects of our child welfare system, I think this piece is important for us to begin a conversation on. This is representation for families during what is across the board a traumatic process. A conversation about that is overdue, and I would fully support Representative Stover's amendment.
Very good. Thank you for reminding me, Representative Perry, about the PTP and the fact that it ran over too. So I've been involved. I guess I've been involved with 3 of those studies. Now that I think about it, and I mean, so what's the worst case? The worst case is that people push back from the table after the 4th visit and said we're not finished. But in the meantime, they've learned a bunch that would help inform either the continuation or a new study with different parameters. So that's why I'm inclined to continue to support the concept. Any other thoughts or questions? So there is the amendment, which would be the addition of HHS to the reporting. Yes, Representative Javner.
Yes, I know we're all looking forward to getting out of here today, but could I please request just a 10-minute corner caucus?
I think that would be perfectly reasonable on a.
Thank you.
Very good. 10 minutes. Well, let's make it 11 and reconvene at 11:15. Looks like we're mostly all back. That being the case, and it being 11:15, thank you for a quick turnaround on the corner caucus. So where we left the conversation was a work session on LD 2027 with offered amendment to expand to include GOC in the report. No, I'm sorry, 1824. Cross that out, 1824. All right, with a proposal to expand to include a report to GOC.
Oh,
Any
it's just
additional?
HHS. I'm sorry.
HHS, right?
Okay.
Okay, we'll go a little slower here. Any other thoughts, questions, concerns? Then I think I would welcome a motion on LD 1824. Representative Meyer.
Thank you, Mr. Chair. I would move that LD 1824 ought to pass as amended.
Second.
Second, Representative Craven, thank you. Any additional discussion, conversation, concerns, questions? Then we'll go to Karen to collect the vote on LD 1824, the current motion being ought to pass as amended.
Thank you, Senator. Representative Zager.
Yes.
Representative Zager, yes. Representative Lemlin.
Yes.
Representative Lemlin, yes. Representative Stover.
Yes.
Representative Stover, yes. Senator Baldacci. Senator Baldacci is absent. Representative Perry.
Yes.
Representative Perry, yes. Representative Madigan. Representative Madigan is absent. Representative Craven.
Yes.
Representative Craven, yes. Representative Connor.
Yes.
Representative Connor, yes. Representative Griffin.
Yes.
Representative Griffin, yes. Representative Javner.
Yes.
Representative Javner, yes. Senator Moore.
Yes.
Senator Moore, yes. Representative Meyer.
Yes.
Representative Meyer, yes. Senator Claxton.
Yes.
Senator Claxton, yes.
That's unanimous of those present with a couple people absent. Very good. Thank you all. Is there additional work to come before the committee before we adjourn? I'll look at Anna and I don't, Sam's still there.
Yeah, and I know he sent you an email with your back of the envelope numbers. I don't know if he wants to confirm that. I also just want to take this opportunity to remind you that we have GOC on Friday. It's a joint meeting at 10 o'clock, and I had forgot to get Karen to put it on the weekly. So not her fault. That was my fault.
And I would suggest, I would just like to add, thank you, Anna, that you should get an email before the meeting with the report, but it will be released on Friday morning prior to the meeting.
So Sam, do you want to report on numbers?
Me, Sam?
There you go.
Oh.
You, Sam, right, sorry.
Sorry, I just had emailed Senator, I had emailed asking about the public records, the right to know for the public records exception for fiduciary. And they said it's probably exempt, but they want to look at it anyway. So I am coordinating. They're going to be doing a round of them next week. So I will coordinate with you about getting that done. So.
Oh, good.
We will.
Can I jump in? Can I jump in there too, Sam? I also just want to let you know that the LIFT TANF bill also has a public records exception. I had also hoped that we could avoid it, but we also cannot. It's existing confidential data, but it's a new collection, so we were also told. So that will be coming your way as well. So thank you, Sam.
Very good. And Sam got back to me to say that that the intensive case managers, there's 24 of them with 2 supervisors and 2 managers. So a total of 28.
So that was some good math, Senator. Very close.
All right. I don't see anybody else with additional Molly's here. We could say hi to Molly as long as you've come in.
Good morning.
Good morning. We're all done.
Happy to have been available and to just be able to say hi.
And Mr. Bugay did fine.
Yes, he did. Thank you. And thank you for your support and help getting that through the loops before session ended. We appreciate it.
Thank you for getting it to us before the last week of session. All right. I'll entertain a motion to adjourn until Friday at 9 o'clock in the morning.
So moved.
When we'll be hearing a bill that will get referenced to us tomorrow. And then try and go quickly into a work session and get it off our table. And then are there any outstanding language reviews at this point? Looking to Anna and Sam.
Well, there's definitely a bunch of fiscal notes in that we don't have yet. Also, I mentioned to you last time we talked about this, that I think you need the final versions of the rate review bill. I don't think there's much, I mean, I showed it to you, but there's not much to be gained until we see what the revisor's office do with it and go back and forth the department to make sure that things are the way they expect. So, but it's mostly fiscal notes, and you will probably, anything we have on Friday, we will bring you, but after that, we will have to do them by email because I believe we're not allowed to meet after Friday.
Okay. And so that'll be 9 o'clock on Friday to hear what's LD 811 is coming to us. We'll deal with that for the next hour. And then at 10, we'll join the GOC for the report from OPEGA number 2 of 3. And then whenever we get done hearing about that, we'll come back to committee and figure out where lunch happens in there. So we're going to finish our committee work as best we can on Friday. Thank you all for hanging in there. All right. So motion to adjourn until Friday at 9. All those in favor? There we go.
See you tomorrow.
Good work.